you didn't do your job, you don't care, you don't know, and you don't care that you don't know, and you don't know that you don't care because you don't care. Thank you, Lally. Got it. You must follow the law. The law says...
Glorious. Is it a lawsuit? Probably. Why not?
Well, hello, everybody, and welcome back to Buckle Up, It's the Law. Folks, today we're going to continue with the evidentiary hearing of Adam Lally from July of 2025. Now, some of you have been asking, what is this about? So I do apologize for not providing specific clarity in the first video, so allow me to elucidate as to what you're about to witness in the second half, in the second portion of Adam Lally's testimony in July of 2025. Now, on July 21st, 2025, an evidentiary hearing was held in Norfolk County Courthouse. Now, as you can see, it's not Auntie Bev. It is another judge. They started the hearing. They never concluded it. It was supposed to resume on August the 5th, and it was with respect to a case called Massachusetts versus Miles King. Michael Proctor was the lead investigator in that case as well. That's why his name is coming up, and that's why Lally is testifying. Mr. King was arrested back in 2021. And the name that we keep hearing over and over, that is Assistant District Attorney, or ADA, Hickman, because Hickman inherited the King case from Lally. Okay? But the particular issue at hand are the 6 search warrants that Lally was originally ordered to turn over, but failed to do so to the defense. And the defense attorney is the one who is cross-examining him about all of this. That is Miss Scapiccio, I think is how you pronounce her name. And she questions him as to what steps he took in order to secure those warrants originally from Proctor, and why he failed to deliver all 6 warrants over to the defense. As you will see, Lally will claim that he has made several attempts, and we heard this in the first half already, he has made several attempts to secure the warrants from Proctor, but he was unsuccessful in doing so. Was it Proctor who was negligent? Was it Lally? It's irrelevant. The point is, there was a Brady violation, right? The failure to turn over discovery by one party to the other, and that is what this hearing is all about. So let's see how this inconclusive hearing concludes at the end of the video today, and get a sneak peek into whether or not there's ever going to be a continuation of this hearing, which I imagine there will be. But when, I guess that remains to be discovered. So, without further ado, let's go.
You get in front of the grand jury. When do you present this case to the grand jury?
Began in July of 2021. That grand jury sat in July, August, and September. The presentation had not been completed at that point, so there was a motion to extend the grand jury. And I believe there was one subsequent date that we went before them on November 19th, 2021.
November what?
19th, 2021, that's when indictments were returned.
In 2021?
Correct.
Okay. So at some point when Mr. King is arraigned, you understand at that point Rule 14 kicks in, right?
Yes. I mean, I'm thinking,
right?
I'm thinking about Rule 14 well before that.
Okay.
And Rule 14, by the way, for the record, that is the you must turn over all the stuff rule. Okay, so when you keep hearing Rule 14, that is the give me the evidence. Where is the stuff? You violated Rule 14, the discovery rule. That's the allegation against Lally.
So when you arraign Mr. King, you still don't have the search warrant. You have another conversation with Trooper Proctor about, hey, where are these search warrants? I have to turn them over?
I'm sure I did.
And do you know when that would have been?
I don't.
Okay. And then, remember at some point in December of 2021, receiving a discovery notice from me. Hey, Brooke, look at your honor.
Yes.
This is just my discovery notice.
That's a discovery motion, or what is
Motion,
that?
I'm sorry, motion, Judge.
Yes.
Okay. And do you remember, after having filed this motion, you asked to kind to go through and make sure that you can comply with all the requests, right?
Yes.
And you didn't have any specific objections to anything that I was asking for, right?
At that time, no.
Okay. May I approach the witness, Ron?
Yes.
Sorry, Judge.
Is that an exhibit? Is that a docket entry?
It is a docket entry, Judge.
Do you know what it is?
I think it
Or we can mark that just so that there's a record of what you're showing the witness?
has my writing on it, Judge. So
All right,
I wanna mark it. But I'll do it after the hearing. I'll find the exhibit and I'll make a clean copy and send it to the court, Judge. So once you get the discovery notice, you know for sure that there are certain categories of information that we're looking for, right?
Yes.
And number one is all automatic mandatory discovery under Rule 14, right?
Correct.
Would you consider those search warrants automatic mandatory discovery under Rule 14?
Very important. And again, this is due to my unfamiliarity with Massachusetts specific rules, and namely Rule 14. Massachusetts Discovery Rule 14 also lists something known as mandatory automatic discovery. And search warrants, by definition, are going to be mandatory automatic discovery. Why? Because these are documents, if you will, tools that the government uses in order to collect, essentially steal legally, right? Evidence, pieces of evidence from you. That's what a search warrant is. We're going to go into your house, we're going to go into your car, we're going to go into your closet, we're going to go into whatever, and we are looking for these items. And if we find them, or when we find them, we will confiscate them. And we will take them from you, and we will use them against you. So those are the 6 search warrants. If you fail to turn over the search warrants, what does that do for the defense? Well, first of all, think about it. The government is saying, we took this, okay, but it goes a step further. We took this lawfully. Okay, show me the proof. Oh, it's in the search warrant. But if you don't provide the search warrants, you see what's happening? That's the problem. Because now the government is saying, look, we obtained this evidence, we obtained it lawfully, and here's the, never mind, you don't need any proof, just trust us. Huh? I'm sorry, what? Just trust us? Trust me, bro, is not a defense in court, Lally.
And we were looking for any and all statements of witnesses, is that right?
Yes.
And we were looking for all exculpatory information, whether
The
tangible.
document speaks for itself.
Okay, that's fine, Judge. So after I filed this motion to December of 2021, you have another conversation with Trooper Proctor saying, give me the 6 search warrants.
I'm sure I did. My general practice is if there is any discovery motion that's filed by counsel, what I'll do is I'll send that to the appropriate police personnel as far as making requests and making sure that they're apprised of what's been at least asked for.
Did you do that in this case? Did you send my motion for discovery to Trooper Proctor, to the Milton Police, to the crime lab, to the medical examiner's office? Did you send it to all of those entities?
Every motion that you filed, yes.
Okay. And then what do you do to follow up with each of those entities? Let's start with the state police. They get a copy of my discovery motion. You're looking for all of the evidence that they have, and specifically these 6 search warrants that, for whatever reason, Trooper Proctor hasn't given you. When you follow up, how long does it take you to follow up from the time that you give them the motion until you get an answer from them?
Specifically, I don't know. Typically, I would give it a couple of weeks or so.
And after a couple, and in this case, did you give it a couple of weeks, you think?
Probably.
Okay. And then what happens?
And then I'll follow up again.
When you say follow up, do you send another email, or do you get in your car and drive down there and say, we got to end this, give me this stuff?
I email or a phone call.
Okay. And so did you email or phone call, or make a phone call to Trooper Proctor in this case?
I'm sure I did.
And what was his response
I
when
don't.
you asked for the 6 search warrants?
Notice how it's the same pattern. Did you do this? Oh, I'm sure I did. I would never hesitate not doing it. When did you do it? I don't recall. What did he say? I don't remember. So what was his response? I don't know. When did you have that conversation? I don't recall. It's like pulling teeth. It's worse than pulling teeth. It's impossible to get a straight answer from these government employees, these liars for hire.
I don't recall.
Well, do you have any notes of your conversation with him? Remember you taking notes?
I don't believe so, no.
Is there a reason that you didn't take notes when you spoke to Trooper Proctor after these search warrants had become an issue? That you wouldn't take notes of what Trooper Proctor told you about the search warrant?
So you're asking me about a conversation that I don't recall specifically when it happened or exactly what was said. So whether or not I took notes for that conversation, I don't know. What I would do typically in my general practice is to follow up with whoever I had outstanding discovery requests in relation to try to get whatever information that I was seeking.
Okay, and so did you follow up with Trooper Proctor about the six search warrants?
I'm sure I did.
I'm getting so tired of hearing the I'm sure I did, I'm sure I did, I'm sure I did. Either you did or you didn't. You know, the Greek have a term for this. Estin euk estin. Either a thing is or it is not. There's no in between. You can't be like half pregnant, you know? It's you're either are or you aren't. You either spoke to Trooper Proctor or you didn't speak to Trooper Proctor. Did you? I'm sure I did. When, where, how, why? Don't know. So the initial answer is completely worthless. He probably didn't, or he did and he doesn't want to say when, or he truly didn't because he's just neglecting his duties as a prosecutor, which shouldn't come as a shock to anyone.
Probably a number of other items.
Okay. And then you knew the case was going in for another date on discovery, right?
Yes.
And you knew you'd have to answer to the court what you've provided and what's outstanding. Isn't that typically how it goes on discovery dates?
Yes.
Did you ever tell the court, geez, I have these 6 search warrants that Trooper Proctor has. I can't get my hands on them. Can you issue an order or can you help me out here?
Did I do that? No.
So when you went to court, do you remember representing to the court that discovery was ongoing and that you were producing as much information as you could? Remember that?
Typically, that's what I would say if that was the case, yes.
Okay. But you knew when you represented that to the court that you didn't have the search warrants, right?
Yes.
So what was your plan? How are you going to get them?
As I stated, what my practice would be if there was some outstanding item of discovery, I would request it and follow up if I hadn't received it.
But you did that. You requested it 5 times. You went to see him. Then you got my discovery motion. You sent that
you
to him.
Do the next step. What is the next step?
And then what happened?
I don't recall.
Yeah, nothing happened.
Well, don't you tell him, get me these things now,
Yes.
coming down your office?
Objection. Overruled.
Did I ever tell him that? No.
Okay. So what do you do when he's not complying with your request? Let me ask you this. What's the policy in the office of the District Attorney's Office in Norfolk County when a state trooper is not complying with a request for discovery?
Objection. Overruled if there is a policy.
Yeah.
What's the policy?
Is there a policy?
I don't know any specific policy related to that.
Okay.
So you just let it go. So you're telling the Massachusetts State Police, former Massachusetts State Police Trooper Proctor, hey, give me the stuff. Hey, give me the stuff. Hey, give me the stuff. Silence, silence, silence. Well, I guess he doesn't have it, so I'm just going to let it go. Is that what we're doing here? Okay.
Do you go to your supervisor's hand and say, hey, I've asked Trooper Proctor 5, 6, 7 times for these search warrants. I've been down to see him in person at least once. He's not giving them to me. What do I do?
No.
Did you ever have another case other than Mr. King and Ms. Gardner's case where a state trooper didn't give you search warrants that you had been asking for since before indictment?
Objection. Overruled.
Not that I recall, no.
Okay.
Your Honor, may I be heard on one slight issue? The discovery, the discovery request the counsel is speaking to, I don't believe it was ever docketed. I don't have a copy of it. I've never seen it. So
The motion. The motion.
Motion for discovery was filed. He got.
it may not have reached the docket. As I guess
I want to make sure that you see it, though. Let's make sure you.
thinking about it a lot here. And
No.
I've never seen it.
Attorney Scapiccio, can you just give it to Mr. McGee for a second?
Sure. You think it would be in the file?
I would think it would be in a file. Is that a clean copy?
Yeah.
That is a clean copy, Judge.
Can we mark that? Should we mark it?
It's unsigned, and it's probably, I don't know if it's a draft or
The non-signed. All right. So let me get you a signed copy, Judge.
I don't know what was.
The bottom line is this witness said he received it, Judge. I know I wouldn't have not filed it. He talked about it in the hearing. And I think there is a transcript, Judge, of a hearing where we talked about the discovery motion and the court had it
All right, we'll
in front of it.
figure that out.
You guys,
We do have the ADA Hickman did have a copy.
You do have a copy.
I never saw it on the docket. I was working right off the docket.
Okay.
so
And just so the record is clear, we have marked it. You want it marked as Exhibit 1 in this hearing?
yes, Judge.
Sure.
All right.
Get you a signed copy.
All right.
By the way, can I just say, Lally's own attorney didn't have a copy of the motion for discovery that is one of the central pillars of this hearing. Talk about negligence. I mean, that's borderline malpractice to be sitting in a hearing regarding signed affidavits that were failed to turn over by the prosecution to the defense. And Lally's own lawyer is like, oh yeah, that motion that requested all of that stuff, I've never seen a copy. When there's a copy in the file, all he had to do was go to the clerk and say, hey, can you get me the King file? There should be a motion for discovery in there. I just need a copy of it. Or actually, you know what? Give me a copy of the whole file. How do you not have that going into this? That is extreme negligence on the part of Adam Lally's lawyer, just for the record.
Right, that will be Exhibit 1.
Thank you. I'd also, at some point, Judge, like to mark the pretrial conference report in this case.
Thank you.
So this had never happened to you before, Attorney Lally, and you didn't go to Lynn Beelan, who was your supervisor, and ask her what to do. What was your plan? How were you going to solve it?
I don't recall specifically having a plan. If there were a situation where I was asking a trooper or a case officer for something and I had not yet received it, I might get that person's supervisor involved as far as saying I've asked for this a few times, I don't have it.
So the natural next question is, did you get Trooper Proctor's supervisor, which is who? Yuri Buchanan? I hope I'm pronouncing that correctly.
Okay, so let's stop there. Trooper Tully was Trooper Proctor's supervisor, is that right?
Tully.
Did you go to Trooper Tully and say, hey, I don't know what the deal is, but I can't get these 6 search warrants from Trooper Proctor. Can you have him send them to me?
Specifically about the search warrants, I don't recall.
You didn't go to a supervisor.
I don't know if I did or I didn't.
So the natural next step to go to the supervisor, you fail to follow. Okay, got it. So you're neglecting your duties as a prosecutor, and you are violating the law by failing to turn over mandatory, automatic, discoverable evidence to the defense. Why am I not surprised, Lally?
But as you sit here today, you don't remember going to a supervisor. Is that right?
I know that there were a number of meetings in relation to discovery.
The sick part is that Lally is going to be protected by his office throughout all of this. They're going to bend over backwards to try and make this look as innocuous. Oopsie daisy. Lally had nothing to do with this. It's a mistake. Leave him alone. They'll go to the ends of the earth to protect him because he's a very valuable pawn, and they know it.
That Lieutenant Tully was present for, along with Trooper Proctor, but going
And when I say he's a very valuable pawn, he is valuable to them. He's completely worthless in society, but he's very useful as a pawn to the Norfolk County DA's office. So just to clarify.
To his office to demand 6 search warrants, I don't recall that.
Okay. So how much time goes by before you ask for the search warrants again?
I don't know.
Is it a year?
I don't know.
During the time period, you had to say that we were appearing in court every couple of months on discovery, right?
Yes.
Did you ever notify the court on any of those court appearances that you were having trouble getting custody of the 6 search warrants that were issued in this case?
No.
Okay. You talked about having meetings, discovery meetings. Tell us what those are.
At various points, probably more towards the early stages, or if there's something that's significant that comes up, it would be just a meeting in relation to this is the discovery that's outstanding. This is what I'm looking for. What's the ETA on this? When should I expect to receive this?
And are those meetings in person or on the phone?
Typically in person.
And do they take place at the DA's office or at the state police?
Well, I mean, in this specific instance, the state police is attached to the DA's office, so it's the same building. So whether it was my end of the hall or their end of the hall, I don't know.
Okay. And do you remember discussing the search warrants and the outstanding nature of the search warrants at the first discovery meeting?
Yes.
And what was the response?
That the search warrants are still ongoing, as some of those search warrants were not just July. I believe it continued into probably September of 2021 as far as the last of the search warrants. I could be off on those dates, but
so how many motions or how many meetings do you have regarding discovery before the return of the search warrant in July of 2021, if that's the date?
Not many. I mean, the murder occurs on July 10th, so there's not a lot of time in between that. So probably 2 at the most.
2, okay. And you don't take any notes on those meetings either?
I don't know.
But I guess I can't figure out, how do you keep track?
Oh,
if
he's
you have
worse
this
than a
list
cop.
that says all these things are outstanding and you're having these meetings because there's things outstanding.
See, when police officers lie like this, I don't know, I have no idea, I didn't check, I'm sorry, I'm not aware, that's one thing. Like they tank the case. When a prosecutor is doing that, they're tanking hundreds of cases, possibly thousands. If Lally goes on the Brady list, which he may already be on there because of this, everything he touches, I mean, we already know Karen Reed, forget about it. But everything he touches or has touched, and he's been there since what, 05? He's coming up on his 20-year anniversary. Think about it. 20 years. How many tens of thousands of cases have funneled through this man in a 20-year period? And now they are all tarnished. They all have just a little bit of sludge on them. Now, in some of these cases, the sludge may be completely irrelevant and useless. In other situations, the sludge is going to be sticky and smelly and useful. And finding and separating which ones are which, that is such a monumental task. I don't know if anyone is ever going to undertake that much of a project, but it's a start. It goes to show that everything that Lally has touched needs to be reviewed, investigated, and studied. Because where else? If he's doing this on one case, that means he's doing it on other cases as well. It's just this lawyer decided to call him out on it. Other lawyers maybe, they rather, a lot of lawyers, sometimes they'll maintain the status quo. Unfortunately, they will throw their own clients under the bus in order to maintain a relationship with the prosecutor. And that is despicable. That is despicable. There is nothing more unforgivable than for an attorney to throw their own clients under the bus just so that they can maintain relationship. I don't care. I will rip your head off if you screw with me as a prosecutor. And they know it. And we have wonderful relationships with 99.9% of prosecutors in the Commonwealth of Kentucky. Same goes for judges. 99.99% of judges we have excellent relationships with. Not because there's the constant looming threat of, I'm going to rip your head off. It's just because we're all in it together. We're all working in this together. We're all getting stuff for one another. We have a reputation to maintain. They have a reputation to maintain. They know us. We know them. There are no surprises. Everything is, it runs smoothly. But when you have this need as a defense attorney to make sure that, God forbid, you don't rock the boat, that you don't do anything to raise the ire, like, God forbid, I pissed them off. You know how many times I pissed off a prosecutor or they pissed me off and then we went right back to the drawing board? It happens from time to time. There is nothing wrong with that. That is the normal course of business as a criminal defense attorney. There's a lot of confrontation. If you're going to avoid confrontation just to maintain the status quo, and like I said, worse yet, throw your own clients who paid you money under the bus just so that you can maintain a relationship with this schmuck, there's a special place in hell for you, Mr. and Ms. Lord. Have you or someone you love been injured as a result of someone else's negligence? Or worse, lost a loved one because of it? I am attorney Larry Forman, and myself and my team of trial lawyers are ready to help you to get the absolute maximum compensation permissible under the law. We know the system. We understand how to win. Anywhere in the United States, 24 hours a day. 1-844-774-HURT. Call us. We can help.
Not taking notes and be reading. How do you know what people are saying and when to expect to discuss it?
So if there was something that specifically was known as far as, this is
switching.
What's going on with this piece, and anticipated sort of ETA on return or something, then yeah, there would probably be a note about that.
All right, so let's assume that the returns came back the latest July of 2021. Let's give you 3 months, August, September, October. October of 2021. Are you asking again for the search warrants that you still don't
We've
have?
been over this time period. I'm trying to figure out you went all the way through arraignment and on the number of meetings and emails back and forth. I get it, but maybe you want to cover new ground.
I'm just trying to figure out, let me ask a question. So when do you realize that you never turned over the search warrant? When do you realize that?
As far as the 2021?
Obviously.
Search warrant in your custody.
In my custody?
Yes.
I would say probably I became aware of it about a month ago.
In 2025?
Yes.
July
4
of
years.
2025 or June of
4
2025?
years.
Yes.
Is the first time you became aware?
4 years.
You didn't turn over the search warrant?
Yes, if I had been aware earlier.
Look, even the poor court reporter, she's just like, are you serious? 4 years? It took you 4 years to learn that's evidence that was mandatory and must be turned over, hasn't been turned over, and let's see, what is that? 365 times 2, that's 730. So it took you about 1,500 days. 1,500 days. Sounds a lot scarier when you phrase it like that. 4 years sounds like a long time. 1,500 days sounds a lot longer, doesn't it?
Then I would have turned over the search warrants.
But you had your list, right? You had your list that said 6 search warrants outstanding, right?
Yes.
You didn't ever check that off, right?
No.
So you knew they were outstanding, right?
Yes.
Okay. And then when did they get to your file?
Again, so as far as my file, they did not. Again, I became aware of it after the case had been transferred from myself to ADA Hickman.
Well, let's talk about that. What date was the case transferred from you to ADA Hickman?
Oh, so now he's punting the ball. Not my fault. This is Hickman's fault.
I'd say probably somewhere in October or November of 2024.
2024.
Yes.
And how does the case, let me just say in general, how does the case get transferred from one DA to another? Is there a policy within the Norfolk County District Attorney's Office of what needs to get done to transfer a file?
No policy, no.
Okay. So what did you do in this case with Mr. King and Mr. Gardner to ensure that your complete file got in the hands of ADA Hickman?
So I physically took the physical file from my office to ADA Hickman's office.
Okay. And do you have a conversation with her?
Yes.
And did you tell her, hey, there's 6 search warrants that I was never able to get from Trooper Proctor?
Again, if I had known or remembered that the 6 search warrants were still outstanding, then I would have got them and provided them. So no, I did not reference that specifically.
But then at some point, ADA Hickman has to come back to you and say, did you not turn over these 6 search warrants? Say that to you?
No.
She never did.
Nope.
Did you ever have a conversation with ADA Hickman about the outstanding 6 search warrants?
Not until recently, no.
Okay. And what transpired?
Objection.
Sustained.
Well, so when you told the court that discovery was almost complete, did you know when you made that representation that the 6 search warrants were still outstanding?
Objection.
I don't know what time frame we're talking about.
I also, as I've stated in my opposition, I've reviewed the FDRs on this from December and February and the other dates in 2025. That statement was never made. So,
That's
and then
why I want a
December
date. That's why I want a date.
and October as well, when Your Honor set this for trial. So I thank you.
So when's the last time you remember answering on this case?
I believe it was December of 2024.
Could it have been January of 2024?
January 2024?
Oh, so let me back that up. In January of 2024, were you still representing the Commonwealth?
Yes.
Okay. And do you remember there being a hearing regarding discovery?
Not specifically, but I'm sure there were.
And do you remember, excuse me, do you remember the court asking about discovery and how the discovery was proceeding?
I'm sure it happened. I don't recall that specific date or what was asked.
Okay. And do you remember telling the court in January of 2024 that you were hopeful that by March of 2024, we could proceed forward because discovery would be complete? Remember that?
I don't.
Okay. May I approach the witness now?
Yes.
It's from when? Yeah, what's the name of it?
January of 2024.
When am I going to get? I know. Show you the request.
May I approach the witness now?
Yes.
I'm going to give you the transcript of the appearance before this court on January 24th, 2024, and ask you to look on page 5 and how they read that, the bottom of page 5 to yourself and the top of page 6.
Yes.
Does that refresh your memory as to whether or not in January of 2024 you told this court that substantially discovery was complete. There might be one or two items that are outstanding, but can we get them to us?
I didn't read that portion. I was reading the highlighted portion. If I could have a moment.
Sure.
I'm sorry, I'm not seeing what you're referring to in that
Well, you're
transcript.
telling the court, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that to the court?
I may have.
Look at lines 16, 17, and 18 on the document that's in front of you, Ms. Lally.
And what page, Ms. Attorney?
Page
like a
4,
transcript.
lines 16, 17, and 18.
If there are lines, it's probably a
The court asks,
transcript.
where are we, Ms. ADA Lally? And you say, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that?
Again, I'm sorry. In the transcript that you handed me, I don't see that.
Let me see, a different one. Do you remember, hold on, let me get this right. Do you remember telling the court, I was wrong, you were right. Do you remember telling the court there may be a couple of outstanding pieces, talking about discovery, that I'll check on, and some other pieces that I was speaking to Ms. Coster about, but I think hopefully that by March 11th, you should be able to proceed forward. Remember saying that to the court?
Do I remember saying that to the court? No. If
Does reading that refresh your memory that you said it to the court?
I didn't read that portion. On what page are we on?
Yes.
You can read from here over to here, to yourself, please.
Sure. Yes, that's correct.
Does that refresh your memory?
Can I just say, by the way, the defense attorney is such a badass. I must commend her on just like her dominance, I guess, in the courtroom. She just walks over to Lally like, here, look at this, read this, yep, and she just walks off. And like, she's very commending of the courtroom. She commends authority. I really like her. She's good.
Only that in the court that you got the right. So maybe a couple of outstanding pieces that I'll check on, and some other pieces that I was speaking to Ms. Coster about. But hopefully by the March 11th date, we should be able to proceed forward. Did you say that to the court?
Well, those are two. So does it refresh my memory? No, but according to that transcript, that's what I said. Yes.
Okay. And you know at that point that there was.
So basically, you don't care is what we're hearing. We're going to get it to the court, is what you say. We're going to get remaining outstanding discovery over to defense counsel. This is January of 2024. This is July of 2025, a year and a half later, and he's just like, oh, I guess I didn't, huh? Well, oopsie daisy. People's lives are at stake here. There's an individual being charged with murder, and 6 search warrants have been executed in order to collect pieces of evidence against them, Mr. King, namely. And Lally's like, oh, documents that show that we followed protocol and did our job correctly. Should I give it to you? Should I not give it to you? Should I find it? Do I care? Not really. I'm just a prosecutor. I mean, I prosecuted an innocent woman, and then I helped prosecute an innocent woman a second time as second chair, and failed both times. It's kind of sad, by the way, that Lally actually got a better verdict than Hank Brennan got a worse result than Lally, because Hank actually lost across the board, and Karen just got convicted of a DUI. At least in the first prosecution, during Lally's case in chief, when he was the lead prosecutor, they were hung on like second-degree manslaughter with leaving the scene of an accident. So it's kind of, I don't know if hilarious is the right word, but yeah.
There's still 6 outstanding search warrants that you didn't have?
No. Again, if I had known, then I would have gotten them and provided them.
Okay. But weren't we talking about search warrants on this day?
You're talking about 2022 search warrants, which were in a subsequent notice of discovery related to a cell tower dump. You were provided all of those as far as the application, the affidavit, the return, and copies of the warrants themselves.
So we're talking about
Selection.
search warrants,
Separate search warrants, yes.
and nothing's ringing the bell that you didn't turn over 6 search warrants?
Apparently not.
Okay. So the 2022 search warrants.
So you didn't do your job. You don't care. You don't know. And you don't care that you don't know. And you don't know that you don't care because you don't care. Thank you, Lally. Got it.
we talked about in court back on January 24th of 2024. At that point, Mr. King was indicted. Is that right?
Yes.
Was Ms. Gardner indicted?
Yes.
All right. So what process did you go through to issue the 2022 search warrants after indictment?
Through this court.
I'm sorry?
Through this court.
So you went to Superior Court and asked for these search warrants. Is that right?
Myself personally, no.
Well, did you notify defense counsel that you were asking for search warrants in a case where a client had already been indicted?
No.
Do you know whether or not there's an obligation on behalf of the district attorney's office to notify defense counsel post-indictment if you're moving to request additional search warrants?
They weren't search warrants that were pertaining to the defendants. They were.
Right. Do you know whether or not there is an obligation on behalf of the district attorney's office, you specifically, to notify defense counsel if you're seeking search warrants after indictment?
Objection. If this is a legal, yeah.
Sustained.
Thank you.
So in any event, we're talking about search warrants in January of 2024. You don't say anything about the search warrants that are still outstanding, those 6. And you tell the court there's only a few things that are outstanding then. Is that right?
Yes.
Okay. And then we come back. We suggest March, and we come back in March. Is that right?
I believe so, yes.
Okay. Then in March, do you tell the court, Your Honor, as far as discovery goes, we're in fairly good position. In regard to that, I believe that was turned over just prior at the last date. So there may be a couple of other additional items of discovery that I need to get and turn over. But otherwise, I think we're in a fairly good position. Did you say that to the court, sir?
I don't.
Finish, Your Honor.
Yes. These transcripts in the FTR, what's on the FTR, what was said by whom, when, is all a matter of public record, and we can look at the FTR and get it. So specific quotes and what was said, what was represented, that's part of the record, and we can see
But I
that.
just have to set it up so I can ask the question that I want to ask, Judge.
Great.
Thank you. So after having made that representation to the court,
The judge is loving this, by the way. This is like the antithesis to Auntie Bev. This is like, if Auntie Bev was the evil twin, this is the good twin. Because he's just like, oh, yeah, I want everything. Please continue.
but did you do anything to get the 6 search warrants?
No.
What were the outstanding matters as far as you understood back in March of 2024?
I don't recall exactly what we were talking about on a court date in March of 2024.
Do you have any notes that would refresh your memory as to what was outstanding at that point?
I might.
And would they be in your file?
If they were anywhere, that's where they would be, yes.
Okay. Now, other than the discovery motion that we filed, did we also file a pretrial conference report in this case?
That I don't recall.
Okay. But you understand normally we file a pretrial conference report where you agree to give me what I'm asking for, and we agree to file motions on stuff we can't agree on. Is that typically how it goes?
Yes.
Okay. And you don't remember signing a pretrial conference report? Not that you didn't, you just don't recall.
I don't recall every pretrial conference report I signed.
Okay. And then we talked about the meeting with the state police. Did you have any meetings with the Milton police regarding outstanding discovery?
In-person meetings? No.
Did you send the Milton police the same type of discovery request that you would have sent to the state police?
Yes.
And did you follow up with the Milton police the same way that you say you followed up with the state police?
Yes.
And did you follow up specifically with Lieutenant Collins?
Yes.
And so what, in your mind, was outstanding on the Milton discovery that you were communicating with Lieutenant Collins regarding?
At what time?
Let's start at the beginning.
Again, it's the same type of information that you asked about before, as far as reports or photographs or any material that they might have pertinent to the case.
So whatever the Milton police turned over to you, would you have kept notes of that somewhere?
Yes.
Would there have been emails back and forth between you and Milton about what transpired?
Yes.
Okay. Did you have any trouble getting information from the Milton Police Department?
No.
When you asked the things, did they return your email and give you what you were looking for?
Yes.
Were there any reports from the Milton Police Department that you say you didn't have before you turned the case over to ADA Hickman?
There was one report, yes.
And what was that report regarding?
Mr. Turner.
I'm sorry?
Mr. Turner.
And what about Mr. Turner?
There was a report in the materials that ADA Hickman turned over in 2025 that was, I believe, offered by Detective Sergeant Clifford Murphy pertaining to Mr. Turner that I had never seen before.
Okay. And do you know why that wasn't turned over by the Milton Police Department?
No.
Did you go down to the Milton Police Department and look through their file?
No.
At any point in time when you were representing the Commonwealth In this case, did you go down to the Milton Police Department and look through their files?
No.
Is that something that you would normally do in a homicide case?
Yeah.
Go to the police officer's office and ask for the file?
At what point in the case?
Oh my
At
God.
any point.
Any point.
Typically, that would be something that I would endeavor to do closer to trial.
Weasel language. Did you catch that? That would be something that I would normally endeavor to do, like, if we're getting closer to trial. Otherwise, I'm not going to do it. Because he didn't. There's just this is beyond negligence. This is beyond gross negligence. This is bordering on intentional withholding of evidence, intentional conduct, and that is unforgivable.
Closer to trial.
Yes.
So how could you make sure your obligation was satisfied
Yeah,
if you're not meeting with the police until right before trial?
that's a cop-out.
An ongoing duty and obligation that extends even beyond a trial.
That's a cop-out.
Right, that's not my point. My point is, if you're not meeting with them and you're not going through their information, how do you know you've turned everything over to the defense?
Yeah.
Because I've requested it and I've been given assurances or information indicating that
You have no
that is what
idea.
they have.
Let me ask
No
you the
idea.
same question about the state police. Did you ever go through the state police file while you were handling the case, as
Just
opposed to
don't
making
care.
requests and even sitting down with the state police to make, face-to-face requests on an ongoing basis and all the follow-up contacts that you had? Did you ever actually request their whole file to go through it yourself?
No.
Okay.
And can you tell us, was there a policy within the Norfolk County District Attorney's Office of sitting down with police departments, whether it's state police or Milton Police, and reviewing their file prior to trial?
Not that I'm aware of, no.
Okay. So how far in advance of trial do you finally sit down and go through, let's take the Milton Police box?
It would depend case to case, but it's something that I would probably do at least a few months ahead of trial.
A few months. And is that the first time that you put your hands on the actual box, or are you still dependent upon the Lieutenant Collins and other officers to give you what you're looking for?
Oh, that would be a time where I'm actually like, let me see the file.
The problem is when you have multiple corrupt agencies working in tandem with one another, this is the result, folks. This right here is the result, is complete incompetence, gross negligence, bordering on intentional misleading conduct. What do you expect? I mean, do you expect anything more, anything less? I don't.
And ensure that I have everything that you have.
Okay. And is there a reason, is there any prohibition to that meeting that you have a couple of months prior to trial happening right after indictment?
No, and that would be my practice now. So you're asking about sort of my general practice at the time?
So I've learned from my mistakes or I don't know. So it's like, well, now that I've been caught, I am going to fix it.
That would have been it at the time, but now I would do that much, much earlier in a case.
Okay. And the state police the same way? Did you sit down with them at some point and look through their file, or you never looked through their file?
No, as His Honor just asked, no, I didn't.
Okay. So I guess my question is, how did it work? Did they only look through their file and send you what you're asking for? Or at any point did they send you, here's everything that we have?
My request and my ask was for everything they had. So as far as me then double checking to ensure that I have everything they have, that would be something that would occur later on. And as I just indicated, my practice now would be to do that much earlier in a case.
Okay. So when you go in this case, you knew we had picked a September 8th trial date, right?
I was aware, yes.
Okay. So you knew the case was ready for trial September 8th. When were you planning on sitting down with the Milton Police and going through their file?
As the case was reassigned to ADA Hickman around the time that we selected the trial date, I don't know that I had a specific plan to do that. I did have a specific plan to meet with ADA Hickman to go through the file to ensure that she had everything that was there.
So by the time she had taken over in January of 2025, you had not made any plans to sit down with the Milton Police to go through their file, is that right?
She had taken over prior to that, but no, I hadn't.
Okay, and the same with the state police, is that right?
Correct.
Okay. So when you're updating ADA Hickman, when she takes over the case, do you tell her, I've never actually seen the files, It's on my list of things to do, but I never got down there. You should get down and take a look at the files.
Not that specific, but yes,
What did you tell her?
that, during the regular trial preparation or meeting with the officers as it gets closer to trial, I would do that, but I hadn't done that yet.
So I still kind of understand. Is there like when the police give you something, do they just email it to you, or is there like a list to say, we gave A. Lally these documents on this date?
As far as their list,
Yes.
I have no idea what they have.
Okay. So you don't know, as you sit here today, if they have an index of all the things they say they gave to you.
I don't.
Okay. And do you, on the opposite side, have an index of the
Even the court reporter is so over this. I mean, just looking at her face
things you got from
brings
them?
me joy.
It would be contained within those requests, yes.
All right. So at some point, do you print out all your requests and say, okay, let me just make sure I have everything here. I've been requesting something since, December of 2021. I want to make sure I have everything. Do you sit down and do that at some point to make sure everything you requested you've received?
My general practice would be yes, and that would be as I know we're getting closer to a trial date.
Attorney Scapiccio, it's a little after 11, and we're going to be able to go until about 11:10. And then I have to break because we're going to have to do the motions to suppress on the two other matters. So we need to think about an appropriate time to break. Maybe now is a good time to break, and we need to talk about another date when we can come back and continue the hearing.
Show your arm.
Okay. Attorney Lally, you can step down. Thank you.
So after he steps down, they pick a date, I believe, of August the 5th to resume the hearing. And it never happened. It either got pushed out or something. But here we are 2 weeks later, 2 weeks and a day, as a matter of fact, August 20th. And there's still no continuation. So we're waiting on the hearing to conclude. So Lally is still in the hot seat. And man, oh man, I mean, that is just egregious. Like I'm off the case, so I don't have to worry about it anymore. I was on it for 3.5 years, and you asked me for discovery. I didn't provide it. I thought I did, but I didn't. But I don't remember if I did, but I don't care enough, so I just punted it to another prosecutor and let them deal with it. Let her deal with it. Hickman's problem now. Not my lane, not my case, not my problem. It's just despicable. I mean, the way Lally and Morrissey runs his office, and the way Lally is just, it's so disturbing. There's a lot of cleanup to do in Norfolk County, and hopefully we will get a chance to see that soon. Hopefully by the end of the year, when Morrissey is finally going to be out of that office. But I don't know. Is his replacement going to be much better? I guess that remains to be seen. So I hope you learned something. I hope you enjoyed it. We're going to continue on with more content coming your way. So tune in every day at 4 p.m. Eastern, 1 p.m. Pacific for a new video. And possibly, depending on my schedule, I'm going to try and premiere a second video, kind of like what we did earlier in the spring and the summer. No promises, but I'm going to try whenever I can. And until then, folks, I will see you all in the next video. Bye, everyone.